I now welcome representatives from the Civil Aviation Safety Authority. Again, I remind senators that the Senate has resolved that an officer of the Department of the Commonwealth or of the state will not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matter of policy or factual questions about when and how policies were adopted. Officers are also reminded that any claim that would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the basis for the claim. For Hansard record, could you please give your name and the capacity in which you appear today?
Certainly, Senator. Shane Carmody, CEO and Director of Aviation Safety.
I invite you to make a brief opening statement before the committee asks questions. Do you wish to make an opening statement?
Senator, I'd like to make some brief remarks if I can, noting some of the statements made today and noting that the committee is intent on giving me an opportunity to respond to some of those statements. Listening to all of the testimony today, there's certainly been some positive contributions to the debate on general aviation, but there have also been some highly negative statements about CASA, some possibly valid, but some that have to be contested because I would argue that they are wildly inaccurate. And I will go through a couple of those when I have an opportunity to do so. It's also a bit disappointing that listening to some of the testimony that many matters are made to sound contemporary when they are in fact not contemporary. I'll give you an example. The transition from the decision not to go with Part 145 and transition to EASA regulations, which was discussed earlier today, was made in 2005, Senator. It wasn't made last week. It wasn't a change in policy that I made. It wasn't a horse jump. It was a very, very long time ago. And the implication that comes from some of these statements is that we're changing horse midstream. And I think that some of the statements that I've heard today reflect that. Also, I would say that in terms of the regulatory development program that we've been running, which we will no doubt get to today, sorry, there's a bit of noise that I can't really, bit of background noise, thank you. The regulatory development program began with the transfer to the Civil Aviation Safety Authority in 1995. Between 2000 and 2010, the consultative framework delivered about 22 regulations. Another 6 regulations were delivered between 2010 and 2016. A number of the people who spoke today were involved in that process from the outset, and they still might be a bit unhappy with the outcome, but they were involved in the consultation for 15 years. Since 2016, I created the Aviation Safety Advisory Panel, and within 3 years we completed the remaining 11 regulations, and they had been made. They were all consulted. They were all consulted under the technical working groups. And some people have made the point that the last 3 to 4 years there has been increased consultation. So those regulations have been made, they have been consulted, and we have made a significant improvement. The regulation program of the 55 regulations are now made. And the implication in some of the documents that the discussions that it's still rolling on, I find a little disingenuous. Senator, returning to a couple of facts that were just made, and I think I will try and deal with them very briefly because I know that you're short of time and you've had a long day. Mr Buckley, clearly we disagree with Mr Buckley. There's no doubt about that. Mr Buckley made the point that he'd spoken to the CASA chair had ignored him. The CASA chair met face to face with Mr Buckley to go through these issues, a fact that he conveniently omits. In terms of industry complaints, he's dealt with the Industry Complaints Commissioner many times, and there are other complaint mechanisms. His information has been with the Commonwealth Ombudsman for some time. That is the next avenue to appeal. And the allegations that I have misled the Ombudsman or the CASA has misled the Ombudsman, I find offensive. The Ombudsman asked us for every bit of correspondence that's been dealt with by Mr Buckley for the last 5 years. We provided 40 gigabytes of data, over 20,000 files to the Ombudsman, who's been reviewing them, and the Ombudsman matter is still going on. Its case is not concluded. I object strongly and personally to the allegations that I have misled the committee. I have not, and I'm quite happy to stand by my record. I also note a lot of comments that Mr Buckley made, and I'll move on to a couple of others, but I would make the point, and I can back this up. Mr Buckley indicated that the transition from one team to another was the beginning of the change. A number of senators have referred to that. I won't refer to the team leader's name, who has since left the organisation. What I will tell you is that the team leader applied repeatedly from 2015 to 2018 to be removed from the supervision of Mr Buckley's case because he felt that his team was wilting under the demands and behaviours of Mr Buckley, and he felt that his team was captured. So he went to his supervisor and asked that Mr Buckley's matter be allocated to another team. And it was allocated to another team, and it was looked at a lot harder. Now, the fact is that Mr Buckley will say that he had a very pleasant journey with CASA employees over a number of years designing his future. The CASA employees didn't quite see it that way. And the CASA employees got to the end of that process and felt that they were not delivering the right outcome, and they asked to be removed from that. Mr Buckley, as you've probably noticed, and you'll notice my emotion in this, has harassed my staff and continues to do so. Under P-Prune and just about every other website. He makes unsubstantiated allegations, and I'm quite happy to deal with them. He has assaulted my staff. He has stalked my staff in the Melbourne office, and frankly, we've had enough of him. So the matter is with the Ombudsman, and I'm very, very happy for the matter to stay with the Ombudsman and get resolved. But I will not accept that. I will not accept the allegations that are made. And I'll make one more point on Mr Buckley. Essentially, what Mr Buckley has been asked to do is one thing: to deliver a legal document between him and his franchisees or his subordinates or whatever he calls them that clearly outlines who has the safety responsibility and supervisory responsibility. Put it in a clearly defined legal document that we will accept, and we would be comfortable with the business model. I'll stop Mr Buckley at that point because clearly he's been told this many times and we're in a very different place, Senator, a couple of other points, if I may, only really briefly. Some of the points that have been made today I think are very, very positive. I listened to Mr McDermott Aviation. I thought they had some very interesting things to say. I note they have a unique business model. But it's an interesting business model, and we try to accommodate it, but it's a different business model because Mr McDermott primarily operates foreign registered aircraft, as he told you, and brings them into Australia. The oversight requirement for the foreign aircraft is by the foreign operator, Senator, so it's kind of handy. He has a business model that operates globally within registered aircraft. It's a good business model and it makes him a lot of money, but it's very different than lots of other business models here, and we have to jump through a lot of hoops to accommodate that, and we've done our best. He mentioned in his submission that he had a lot of outstanding jobs. I went through the outstanding jobs and found that more than 70% of his 60 jobs had been completed within 30 days. I'm quite happy to put that evidence on the record, but I think as a whole, his submission was very positive, and I welcome it. I was very disappointed with the AOPA discussion, and there are a couple of points that I must make about the decades of aviation medical abuse. In the last 12 months, Senator, we approved 25,000 aviation medicals and rejected 84. That is hardly systematic abuse. That's 84 rejections out of 25,000 applications. I object to the fact that we've thoroughly ignored him. We write back to him all the time. With regard to the points that he made, which I note the committee noted with interest, the young pilot accused of low flying, and it's not true. Well, that's not what the instruments on his aircraft say, Senator. They say he was at 125 feet. So I have to
get into the specifics of this individual case unless you want to flog it out. We don't have time for that.
No, Senator, I don't. I wanted to make he raised 3 points.
Please continue progressing.
Yeah, pardon? I'm sorry, Senator, I missed that.
Please continue progressing without getting into. We will run out of time, which would be unfortunate.
Thank you. It would be. So there is a different side to that story. The AAT fellow failed. The AAT fellow, if it's the same one we refer to, is a person who's failed multiple flying tests and is back in the AAT. And his licence is going to be reissued, is subject to him passing a test, and he has not. And the third matter relating to the aircraft registration, it concerns me that point is made when that company misrepresented the aircraft when they introduced it into Australia. It's a self-declaration, and we caught them. I would also say that the legal representative for that company is actually on the AOPA board, something that does not get mentioned. So we get the issue raised, but disingenuously, not completely. There are a range of other elements that I covered. The reg program, as I said, is pretty much complete. There are lots of other issues, I think, related to pilot qualifications. Some are raised by the 4A's Association. I did note that they said, because I wrote it down amongst other things, that matters have improved considerably over the last 4 to 5 years, which I thought was helpful. And there's been some minor changes to Part 61 in the last 6 months, and there's a very extensive working group trying to change Part 61. Part 61 was a regulation that was implemented well before I arrived in CASA, Senator, and we're doing our best to modify it. And there was some discussion on Part 138. I might stop it there, Senator. I know that we're very short of time, and I know that you want to ask some questions, and I'd welcome the opportunity to respond, and I have some officers here if I find that I am out of my technical depth. Thank you. Can't hear you, Senator, I'm sorry.
Thank you. I said thank you, Mr. Carmody. I hope my questions will be dealt with a little bit more thoughtfulness than the complete rejection as you've just gone through. And I suspect that this is some of the response that some of your CASA complaints have come from, is this sense of not being heard.
Excuse me, Senator, I'm sorry.
So my question is, would you like to hear my question, Mr. Carmody?
Certainly.
Or did you have a comment to make? Please talk.
Senator, I just wanted to say, please, I'm not in a position where I'm completely rejecting. I'm offering another point of view. The point of view was made very strongly by people, and I'm offering another. That's all.
No, you did say you rejected, and you did use that language, so I was just reflecting on what you'd said.
I'm sorry, yes, I did. The allegations against me, I reject.
So I want to ask you, at the last budget estimates, I asked you a question about Mr. Buckley, and I did try and clarify it to confirm the completeness of the information that you're providing, and that whether or not it was the only matter that you were aware of, and you said yes. And given that I've subsequently discovered that there are other matters afoot, I felt like it was, you have said you didn't mislead the committee, but I certainly felt that you had not been fulsome in your answer, and I didn't think that was a satisfactory response. Do you want to expand on that now?
Certainly, Chair, love to. I think that you said, I want to raise Mr. Glenn Buckley. I responded and said, I'm aware of Mr. Buckley, yes. You said, is it correct that there's been a settlement made with Mr. Buckley recently? That was your question, and I said, partially, there has been no settlement made. Mr. Buckley put in a complaint about a CASA officer with regard to defamation and said the CASA officer defamed him. That was in the context of the only settlement offer that has been made, which was the question you asked. I went through that. You said, do you want to consult with your internal lawyers to check that that's current? And I consulted with my lawyers, and it was current. And you said, and then you moved straight on. You said the industry is following with great interest, and then you went on to Part 138. Senator, I was quite happy to answer more questions about Mr. Buckley. But Mr. Buckley, there has been one offer of a settlement to Mr. Buckley, and that was the matter that I raised. There has been no other offer to the settlement for a settlement to Mr. Buckley at all. He's made claims for years.
Being a lawyer and not having enough technical accuracy to have teased out what was patently a range of other issues that were afoot with Mr. Buckley. So, yes, technically you're quite correct, but if you were my child and we were having that conversation, I would feel that you'd not been completely honest with me, and that was the sense that I was left with, which was that you just left stuff off the table.
Senator, well, that was not my intention. I did answer fulsomely with regard to that question, and then you moved very quickly on to part 138, which surprised me. But you wanted to ask questions about 138, and so therefore I went on to 138. I was not intending to mislead. I had a stack of information on Mr Buckley, the same information I have now.
No, well, it did surprise you, obviously, because you had a whole lot of other things you could have said, and
Absolutely.
you know, you left it unsaid. So note to self, hey, that I will have to ask more broad questions in future. I want to ask you about this concept of an independent complaints commissioner. Can you tell me why we got into this situation that what could potentially have been resolved much earlier with a better process was actually, I think Mr Buckland's words were that because the document was off the table, that there was no problem to answer. Can you expand on that for me?
Senator, I'm not quite sure I can. The reason I say that is there have been multiple interactions between Mr Buckley and the Industry Complaints Commissioner. I'm just not sure, I just don't have in front of me the document that he's referring to that we allegedly said was now off the table. I do note that there have been interactions, but as I said, to be open and completely frank, the whole matter is with the Ombudsman, and everything that we have done with Mr Buckley is at the feet of the Ombudsman, and I'd be very happy to see that process work through.
It is most fortuitous for you that it is before the Ombudsman, because it will not keep discussing Mr Buckley's individual circumstances, because as you say, it's been considered by the Ombudsman. But I'm telling you, and I have raised this before, and we have had a frank discussion about this before, that I hear this all over Australia, that people, individual little businesses, don't have the capacity to go up against your legal team, and this very adversarial approach, which means that small businesses, general aviation businesses right across Australia are being crippled by this very approach. Perhaps we could talk about consistency, where you've made comments around your desire to see consistency in the business. How's that project going?
Senator, quite well. Just to close out on the Industry Complaints Commissioner, if I may, and I'll go to consistency. The Industry Complaints Commissioner is one person with a staff of one. He's not supported by the CASA legal team. He is a lawyer by training, but he conducts his investigations completely impartially and reports to the board. He is very clear, he doesn't seek that engagement that's being referred to. I accept the fact that people might have difficulties with regulation and may have difficulties with the CASA legal team, but the Industry Complaints Commissioner is a very clear process put in place in around 2006, 2007. He deals with about 130 complaints a year, and as far as I know, he deals with them quickly and efficiently. But sometimes people don't get what they want. Senator, in terms of the second point you raised about consistency, it is a huge challenge. We are restructuring our organisation to create a central guidance function so that we can deal consistently with matters across the country. I do note that some people at the same time gave evidence today that they don't want to deal with the central element, they want to deal with their local office. It makes it extremely difficult, Senator, and we can deliver consistency.
No, just to clarify, the evidence that was given by that person said that they didn't want to end up with a central agency that would take a very long time, because businesses will go to the wall if there's not a sense of urgency.
Senator,
I don't think she was objecting to a central agency. She was concerned about the amount of time and money that would take.
Thank you, Senator, for the clarification. I think that what we are proposing in terms of guidance is that our local officers will always have one place to go, only one place, to seek guidance before they make a regulatory decision. So we will always be consistent across the country. We've been doing that with, we've trialled the arrangement already. We've been doing it with things, we've said we'll put the same arrangement in place for review of fatigue rules so that the same people will look at all of the applications for relief from fatigue rules. So we are moving very much to that centralised function, and it's taken a long time, but it is a fundamental structural change to the organisation, because we have a lot we've had a regional structure for a very long time and a lot of regional experts who deal with their, very closely with their local constituency. So we are working on it, I know the trial's through. I'm not sure of the date, but I expect part of the structure to be in place by early December of this year, so that it actually beds down by the middle of next year. But that's a key element of our approach to becoming more consistent. And in developing that process, it's been quite challenging because consistency and outcomes-based regulation don't always work together, if I can put it that way. Consistency can be binary. We are trying to come up with consistent decisions to complex regulatory matters that can apply across the country, and it is quite a challenge.
All right, I need to hand over to some of the other senators. I just want to clarify too, Mr Buckley, when he asked to see the chair of the board, that he did actually make that point. He said after 6 months he had a response. I just want to be clear that there wasn't, that he met with the chair and with a staff member of CASA, who was later the person who wrote to us that his employment be terminated.
He did meet with the chair. That was probably about 12 months ago. It's just at that point it didn't clearly come out. He has corresponded with the chair and the board on a regular basis. He writes matters to the board, and the emails that he sends are always responded to. Senator, we make a point of responding to all of the correspondence, and so the. Well,
is that you or is that the board?
That's the board. That's the board makes the point of responding to all of the correspondence. I respond to it all. I've got 3 lines of inquiry that run with Mr Buckley. I've got a single point of contact in the organisation because I cannot not respond. The board secretary has a single point of contact and responds on behalf of the board, there is one other line as well, so that we manage to ensure that we are always responding to Mr Buckley and we are always being appropriate and consistent and timely.
Well, unfortunately, it hasn't saved his house or his parents or anybody else, so that's a most unfortunate outcome for Mr Buckley, isn't it? And I'm sure that none of the CASA staff have had to bear anything near that financial impost.
Senator, it is a tragedy for Mr Buckley. I understand the points that are being made by Mr Buckley, as I indicated before, and Mr Buckley made the point, I think, that we, in terms of the notice that we provided in October of 2018, that was for allowing him to expand his services, which happens all the time. We did not approve that. We did not stop him operating. We allowed him to continue to operate under his current arrangement. I can't speak for his house or his family, and as I said, I'm very sorry for Mr Buckley, but I'm quite happy to answer for the approach that we have taken with Mr Buckley. It has not been perfect, but it has not been perfect from both sides.
Senator Patrick, do you have some questions?
So you are obviously aware of the changes to the Civil Aviation Act in October last year.
Certainly.
Can I get an understanding of what CASA has done in response to that change in legislation? So have you set up committees? Have you set yourself objectives? Those sorts of things to achieve the command in the provisions.
Senator, the provisions are very clear. It is a requirement for us to take cost into account, I think, in the development of essentially take cost into account in the development of manuals of standards and other things, which is what we do, and we have a process in place to do that. I might bring Dr. Alec up to the table if I may, because he may be able to speak to it more accurately than I can.
So the requirement is that you consider the economic and cost impact on individuals, businesses,
correct,
and the community, and that you take into account the different risks associated with different industry sectors. Can I just, maybe just to help the context of where I'm coming from in this question, the Parliament and indeed the government and the Parliament developed this out of the concern that people have expressed to various committees over time as to the increased regulatory burden. And so I would be hopeful that I would be hoping that this is not just being seen as some small issue, but that you genuinely are looking at ways in which to reverse the trend that people are telling us about.
Senator, we do genuinely look at cost. We look, during the technical working groups that have been referred to today, it would be fair to say that industry members are always referring to cost, and we're always considering trying to ensure that we do not increase I'll call it cost, I'm calling it cost in the broad, the burden on industry and trying to reduce that. And we have processes in place to do that. Dr. Alec might refer directly to the legislation. We're trying to make sure that we're absolutely compliant with it. I think that people have different expectations of what it might mean and how you would apply it.
And that's what I want to get out on the table. So I have a definite view on what that means, and I'm trying to understand what CASA's view in respect of that change directed by the Parliament.
Jonathan.
If I may, Jonathan Alec, Executive Manager, Legal International Regulatory Affairs. We were very conscious of that change, very well aware of what it would imply. The language, as you probably know, Senator, was taken almost verbatim from the Minister's Statement of Expectations. And at the time, we were aware of the fact, as were those who participated in the introduction of the legislation, the second reading speeches, that this provision enshrines what CASA was meant to have been doing anyway. That those expectations about taking cost and risk into account are expressed in our regulatory philosophy. They're expressed in the director's directive that's been around about risk-based legislation. And by putting it in the Act, in the course of the second reading speeches, it was made clear that this was making the importance of that expectation as clear as it could possibly be. So, legally, of course, it creates a duty, a legal duty, where previously there was an expectation.
Sure. So if I listen to what you're saying that's business as usual because you felt that prior to that point you were doing that anyway.
Well, we did, but I must say that cognizant of the fact that this was now a legal duty, we made it very clear that as this is now a duty, the expectation will be that we'll be able to demonstrate in a much clearer way how this was done. We provided guidance and direction to our those in our organization who are responsible for developing standards under the provisions of the Act that are referred to in the amendment. What these terms mean, these terms take into account, have regard to, these are terms that have been dealt with in legal context. So I said, if you're going to comply with the law, you need to know what that means. And it does actually impose a new discipline. And in the process of developing...
So the burden of my original question was, I don't necessarily want to get into a legal discussion. I want to know what CASA has actually done. So, and maybe you can do this on notice. You can spell out, look, this legislation passed, that caused the board to do this, that flowed down to this activity being carried out, these new KPIs being set. Okay, maybe that could be done on notice.
For your notice, Senator, if that helps, noting the time, what we've implemented to implement the change. Okay. If that would help, and then that can be subject to further questioning.
And any objectives that have now been set. And I wonder if you could, and maybe not on notice, but do you see this as something that needs to be applied retrospectively to not in a legal sense of placing the duty on you before the legislation was passed, but looking at the current legislation and looking and saying, how do we take that legislation or those regulations that are in place and now fit them to the new legal duty that you have? Is there any effort being conducted in respect of that?
There is not, Senator. I've looked at it in a slightly different way, but with the same outcome, and that is we worked very hard to complete the regulation suite because it had been going on for so long, and therefore various iterations of that regulation suite came to life at different times, if I can put it that way, over the last 25 years. That's why my focus was on completing the regulation suite, because my strong view is that we need to look at the entire regulation suite again. But we couldn't change horses midstream. We improved the way we do regulations, but we couldn't change it midstream. And within the context of that, reducing the regulatory burden is a clear element within that. But we needed to complete.
Okay.
Stop arguing over the first bit.
I understand the proposition you're putting. Thank you very much. But the second part therefore implies that you might be rolling out a plan, having completed the regulations, to now walk back through these regulations and say, how do we get these things, and I'll use the words of the witnesses, looking like New Zealand's, looking like the FAA's and so forth.
And Senator, to be frank, we're actually doing that. There was discussion today about Part 61. There's a ongoing review, a technical working group of Part 61. Part 61 exists. We're endeavouring to streamline Part 61, change it, make it more fit for purpose, so that we will be able to change Part 61. Okay. So a lot of those things are alive in the context of the work we do. But I was talking more generally about the entire suite. And we also said to industry, what are the regulations, aside from the fact that we're trying to complete, what are the regulations that bother you most? And Part 61 is one that bothers the industry most, so we focused on it. Okay,
so if you wouldn't mind just explaining in a story about what you've done as a result of that, meetings, objectives, what outcomes you've met. But I will go back to one other point. This is my last line of questioning, Chair. It was raised in the hearing. It's clear that you were listening in relation to Part 138. So that is a regulation that I understand is being worked on post the changes to Section 9.
The regulation was made and the Manual of Standards has just been made, Senator, yes. Okay,
okay. So this is a regulation that has been put in place after the change in Section 9 of the Civil Aviation Act. Now, it was put to us that the technical working group went through a process, pushed some dissenting or provided a dissenting report in respect of the propositions of CASA. I know you said that you engage in consultation. The evidence we've heard today in relation to that particular committee was that it was not necessarily consultation with, but consultation to. And you're allowed to push back on that. But what I would like to see, and I did ask the witness to provide us some information, but from your side, perhaps if you could show us, and this is what I'm particularly interested in, you clearly developed this Part 138. I'd like for you to demonstrate to us how, in engaging with a technical working group, that might have brought about at least some changes to the regulation. I'd also like to see their dissenting report, if you could provide that to the committee. I just want to understand that particular process, and I want to see how the engagement occurred and what the result of that engagement and consultation was.
Senator, certainly. I listened to that dialogue today. Let me be absolutely clear. There is nothing in that process that is not available to this Parliament.
Sure.
So we will provide all of the material around the technical working groups. So there was a discussion about could we before. Obviously, we would do that.
Sure.
There was some...
I think the witness was just being cautious.
Yes, I believe so too. That technical working group has been, in one form or another, going for nearly 20 years. Mm-hmm. The technical working group did, at the end of the day, have a dissenting view, and that's not the first time we've had a dissenting view. The Aviation Safety Advisory Panel received that advice and discussed it, and they came to the conclusion that they would recommend, regardless of there being dissenting views, the amount of work that had gone on within the development of Part 138, the significant work that had reduced it from 200 pages to 75, the significant changes that had been made during that discussion, they would recommend that the Manual of Standards be made. So as a consequence, that recommendation came to me, and I made that Manual of Standards. Sitting behind that, I'm very happy to provide all the documentation that supports how it got to where it got to, and you'll see the changes, the iterations, the dissenting reports, etc.
That's what I'd like to see. Now, the other point that was raised, and I'm happy to do this in a de-identified way, but that the proposition was put that the experience levels in terms of people who actually fly, people that own a business and so forth, was much greater on the technical working group than it might have been on CASA's side of the ledger. So I invite you to perhaps de-identify the people, but just say these are the people involved, this is the levels of experience that these people had. And I'm only talking about over the last year or so.
Certainly. Senator, happy to. I'll make the point just on that reference that one of the key drivers in the technical working group who was working directly for me for a while and went back to Part 138 about 6 or 8 months ago, has a commercial pilot's licence, commercial helicopter pilot's licence, and has flown in Australia with his helicopter domestically and has flown internationally. And my view is that he is well versed in rotary wing operations. So I'm very happy to put that on the table, and I'm very confident in the young man and his ability.
Sure. I'm actually giving you the opportunity.
I agree, and I will do that. Very happy to
lay that out. I think I've probably used as much time as I'm allowed. I'd ask more questions if there's time, but I'll look to the chair.
Thank you very much, Senator Patrick. I just have a quick 2 questions that I want to ask Mr. Carmody. So just following on from 138, Part 138, so CASA staff are going to be really busy if they're going to be ready for the implementation of Part 138 by December 2021. And if we work backwards from that date, do you think there is time for them to implement the regulations, get out training, make business decisions on what they need to do? This is industry I'm talking about. Develop their ops manuals, particularly given the consistency issue that we've just gone through. Have the ops manuals accepted, approved, negotiated, and receive their correct certificates or AOCs, or have them amended, given the Part 61 introduction experience? Or are we going to end up in December 21 having to kick it down the road because, with the pandemic and everything else that was happening, this was never going to be achievable?
Senator, thank you for the question. The complicated regulatory suite, which is the one that we've delivered over the last 3 years, are the ops regs. They're the most difficult and complex of the regs. Included in that, they were all delivered and they will come into effect into implementation in December 2021. We made a commitment to industry that we would provide them with a full 12 months of transition. So they've been consulted on the content of the regulations and on the content of the manual of standards. They are involved in the consultative processes at varying degrees. I accept that some people say they were less involved or more involved, but industry was engaged to the extent that we felt we could engage them. We've provided, as we undertook to industry, a full 12 months of transition, which is one of the reasons we were pushing to try and resolve Part 138, so we would give industry the full year. We know in our previous experience in regulations that the more time we provide, the later the transition happens. We've been training our people and we're trying to train industry as well.
So the transition will commence in December 21 and there'll be a 12-month period from there.
It is effective in December 2021. So the training and transition happens now. Like over the next 12 months, people are understanding how they're going to transition. We are explaining to them, if you like, the linkage between the previous regulation and the new regulation, or the linkage between the previous standard and the new standard. We're making sure that our staff in our offices understand that this now means that. We're doing the same thing with industry. We have an extensive public relations and consultation campaign to make sure industry is ready. But I don't think what is in the regulation, which was made a year ago, I think it was a year ago, and what is in the manual of standards that have just been made, are not invisible to industry. They've been aware of them. Been aware of the Part 138 regulation now for more than a year. They know what's in the Part 138 MOS, so there is time, in my view. That's what I'm saying.
There'll be a sense of urgency from the department to get the manuals approved, to get amendments to current certificates if required. You're not going to be, leaving with people without enough time.
I don't believe so, Senator. And we've worked quite diligently to provide enough time. So it'll be challenging.
And you'll be giving that direction to those staff to expedite those. We wouldn't want anybody falling outside or being, having problems in December 2021.
Senator,
Look,
when we
I've
did...
just got a more question.
Yep, certainly.
I'm concerned because we've had so many industry witnesses today. I speak to people all around the country who are making these same comments about people who facilitate and people who don't facilitate, and the culture at CASA. I'm reflecting on the fact that Air Services Australia has been through a cultural review. I'm reflecting on the New Zealand Aviation Authority that is also doing a cultural review. Is it time that CASA has a cultural review?
Senator, I don't believe so, but it's probably a matter for others. There will be pockets within any organisation of poor culture. I have had to take action on matters over the last 3 to 4 years when I've run into a cultural problem. I've had to take action on conflict of interest and remove staff. I've had to take small action on gender-related issues and remove staff. You will always in organisations have that. I don't believe there is an entrenched cultural problem. I would say that we have more of a male-dominated organisation and a male-dominated industry, but we've also worked hard. I've got a number of senior level women in the organisation that we've been actively pushing and promoting as we try and improve that balance. So my view is that there is not a cultural problem per se, but you will always find small issues.
I guess it would be interesting to get an independent person to come in and make that assessment, because it's certainly something that's raised over and over at Senate hearings, and it is raised privately across the country. Would the industry be open? Would CASA be open to an independent review of that?
I think industry is raising a different cultural question than I'm talking about, Senator. I think they're talking about the culture of the inspectorate and how it deals with them, rather than the culture of the organisation per se. Maybe I'm misunderstanding something. There's an element. There's probably a little bit of both. I mean, from my point of view, I believe that I don't have any issues, and I'm quite happy to speak to the board about that matter. But as I said, you look and you will always find something. But we're a regulator, Senator, and people don't always like what regulators do.
I don't disagree, but I guess it's interesting that we've got other aviation-related organisations that are having reviews currently and have discovered problems, and that you don't believe there's a problem. So we might pursue this at another.
I think Air Services did a review because they discovered they had a problem, Senator. They didn't initiate a review. They had a matter that had to be dealt with, so they had the Broderick review. But Senator, look, I can't defend entirely what I don't know. There'll always be cultural challenges in organisations, and as I said, we're a regulator. There'll be areas where we will conflict.
Senator Sterle has very graciously allowed me to take up his time, but we will be talking to you again, CASA again. So. Thank you for that, Senator Sterle. That does lead us to the end of time. It concludes today's hearings. I do thank all witnesses who have appeared, especially those who have travelled to be here. Thank you also most sincerely to Hansard Broadcasting. And this committee stands adjourned.